For my ethical case, I am discussing something very relevant. It is about two athletic trainers who acted without licensure or board certification. At Lackawanna Junior College, an athletic director Mecca, hired on two women, Coyne and Bonuses, to be the athletic trainers for football. However, these two women did not pass their boards, but continued to act as athletic trainers even after AD Mecca changed their job titles from athletic trainers to first responders because football still needed medical staff present. So during 2010, two boys on the football team sustained an injury. Justin Reich sustained a T7 spinal fracture that was taken care of by Coyne, and Augustus Felicia sustained a brachial plexus avulsion after being taken care of by Bonuses, and how this happened was during an Oklahoma drill for both of the boys. So with Bonuses, she took care of Felicia. Felicia came off complaining of a stinger, and Bonuses just said, you can go back in once you're starting to feel better, and then it ended up being a brachial plexus avulsion. Really bad. So Rice and Felicia initially sued AD Mecca, the two football coaches, and the two athletic trainers for bodily damage and negligence. However, the initial ruling ruled in favor of Lackawanna Junior College because all the athletes needed to sign this waiver. And the waiver says, I hereby elect to voluntarily participate in said activity, knowing that the activity may be hazardous to me and my property. I voluntarily assume full responsibility for any risk of loss, property damage, or personal injury, including death, that may be sustained by me, or any loss or damage to property owned by me as a result of being engaged in such activity. So this wording basically caused the two boys to lose their case. Now, this case that I am reviewing is the appeal of the case that got sent to the Supreme Court of Pennsylvania. The main concern that was being reviewed in this waiver, this whole case is because of the waiver and the negligence, gross negligence, and malfeasance of Coyne, Bonuses, and the rest of the athletic staff. Because in this waiver, it has another section that states, I do hereby offer my voluntary consent to receive emergency medical services in the event of an injury during an athletic event provided by the athletic trainer, team physician, or hospital staff. Nothing in that mentions a first responder, which is what Coyne and Bonuses were supposed to be acting as. But they were acting as athletic trainers without a board certification or a licensure. So this is where it gets interesting. The panel on the court determined in this regard was based that Lackawanna had a duty of care to the the athletes, to provide them with adequate care. So essentially, Mecca started a downward spiral of events by hiring on two unqualified women to be medical staff, because I don't know why. And even Coyne and Bonuses, their preceptors and professors even stated in an affidavit that neither one of these women were well equipped to handle the rigors of football or to even be athletic trainers, regardless of passing their boards or not. So that's a good synopsis of what this case is about. So my stance on this case is I defend the ruling. The ruling of this case was ruled in favor of the 2 football players. So I stand in defense of that because according to ethical theory of beneficence, autonomy, non-malfeasance, and justice, a lot is very much incorporated in this. So the legal issue at stake, in this, is there was not properly trained staff and that were hired. No board certification, no licensure. That should be an automatic red flag that you can't get a job. There were probably more qualified candidates. For whatever reason, Mecca hired these women. I don't know. I wasn't there. I don't know their thought process. So when thinking about ethical theory, beneficence, neither Coyne nor Bonacieux acted in a way that benefits the patients. If they wanted to benefit the patient, they would not have acted outside of their job description. They would have acted as a first responder and not pretended to be the athletic trainer. And then even step further to protect or to benefit your patient, you wouldn't have accepted the job. You would have turned the job down and said, I'm sorry, I'm not certified, I'm not licensed, I can't accept this. Then again, that goes into morality, which is another ethical debate. So what are these women's morals? We don't know. The issue of autonomy, though, goes back to the 2 football players, Reich and Felicia. They signed the waiver of liability, and no one forced them to sign that waiver. They made the decision to sign the waiver themselves in order to play football. However, this waiver only gives the consent to receive emergency treatment from an AT, team doctor, hospital staff. Nothing said about first responder in there. So these boys were signing the waiver under the impression that they would be receiving adequate treatment and proper personnel would be treating them. Non-malfeasance, do no harm. There was a lot of harm in this. Hiring unqualified people, continuing to do a drill that already injured one and then injured another, continuing to act outside of your job title, all of that caused harm, which led up to this entire situation. Justice, the justice part of this is the waiver was looked at a more legal perspective instead of just the black and white. It looked at, there was no mention of negligence in the waiver. There was no mention of recklessness in the waiver. Nothing mentioned that, which means that Coyne and Bonacieux were not protected against negligence and recklessness, which is how they acted. So when we think about this is illegal and unethical. I can see why Mecca hired on these women, because they needed staff. They needed 2 athletic trainers for the football team. And football is a big thing in Pennsylvania. So it could be a cultural thing, or it could be out of desperation. But everything linked in this, why the women accepted the job, why Mecca hired them, why the coach continued to do the drill, all links back to morality. What are these people's morals? Do they want to protect their athletes and their patients? Do they want to protect the people that they said they would do no harm for? So in summary, I do defend this case. I do defend the ruling of this. I am just astonished that this even happened. So this can apply to like future athletic trainers, especially people my class who is graduating very soon. Do not accept a job if you do not have your license or your boards. Keep going until you get that, and don't accept a job where you know you are not qualified to be at.